and welcome to Bloomberg Quint. You're watching the fine print. An insolvency application, conditional stay on it, settlement offer, desperate attempts to sell assets, reneging on the settlement agreement, contempt of court, potential jail term and payment. The Reliance Communications and Ericsson saga has gone through all imaginable twists and turns. In a playwright's parlance, this was Act 1. Act 2 is just getting started. But first, a quick recap of what's happened so far. Operational creditor Ericsson initiated insolvency proceedings against RComm for its unpaid dues in September 2017. The application was admitted, but RComm fought for a stay on it, which was granted to it on the condition that it will pay 550 crores to Ericsson as settlement amount. RComm and its chairman Anil Ambani agreed and gave an undertaking to the Supreme Court to pay this amount by December 15, 2018. In the interim, the company tried to sell its spectrum assets to Reliance Jio but failed to get DoT nod. The clock on the settlement agreement kept ticking. The company missed two court-granted deadlines, which prompted Ericsson to file contempt petitions against RComm and Anil Ambani. Finally, in February this year, the Supreme Court found them guilty of contempt, granting RComm and Anil Ambani 4 weeks to pay Ericsson, failing which 3 months imprisonment was directed. Just as the 4-week deadline was about to expire, RComm paid up. This was Act 1. Two important aspects are now playing out in Act 2. First, Ericsson needs the Supreme Court's approval to withdraw its original insolvency application. Second, when the NCLAT had stayed the insolvency process against RComm, it had said that if RComm is admitted into insolvency, Ericsson will have to return the money to the company. So, before the Supreme Court now, Ericsson is arguing to withdraw its insolvency application and RComm is opposing it. So, will Ericsson's 550 crore rupee victory be short-lived? To answer that, I have with me Pooja Mahajan of Chandeok & Associates and Sudipta Routh of Indus Law. Pooja, let me start with you. How should one look at this payment to Ericsson? Is it a settlement amount pursuant to a court order, or will it, in case IBC proceedings are allowed to continue against RComm, take the color of a preferential transaction, which, for the benefit of our viewers, is defined under IBC as a transaction where the property of the corporate debtor, in this case RComm, is transferred to a creditor on account of a debt, and such transfer places this creditor, in this case Ericsson, in a position which is beneficial compared to where it would have been in the hierarchy laid down in the code. So money got paid to Ericsson, and as a result of it, Ericsson got a better treatment compared to the financial creditors of RComm. Pooja, will it be a settlement offer or eventually take the color of a preferential transaction?
See, to begin with, as of now, it's obviously a settlement offer. The fact whether it's a preference or not a preference is something that, according to me at least, is not something that needs to be decided right now. A preferential transaction under the code is a transaction, as you very rightly put, which prefers one creditor over the other during the look-back period. The look-back period in this case would be 1 year prior to the insolvency commencement date. Now, to set aside a preferential transaction, it's the resolution professional who needs to file an application to the adjudicating authority after forming an opinion that a particular payment is a preference payment or not. And if the adjudicating authority is satisfied that a payment is a preferential payment, in that case, it has the authority and power to reverse that particular transaction. So according to me, as of now, there is no question of payment back to RComm from Ericsson, because that stage of determination of preference transaction hasn't really arisen. That will only arise if the company gets admitted to insolvency, and once the RP makes that determination and makes an application to the adjudicating authority for reversal. Now, coming to the second question as to can this potentially take the color of preference? I'm not very sure right now, because you see, the way the law is currently drafted, it doesn't really go into the question of whether the corporate debtor had any intention to prefer or not to prefer. It doesn't really go into the question of whether corporate debtor was forced to give a payment pursuant to a court order or not. It simply says that a preference is where corporate debtor makes a payment or a transfer which actually prefers one creditor over the other. When you look at the earlier case law on this, when we look at Companies Act 1956, we look at some of the case laws in UK, there are a series of cases which say that anything pursuant to a court order or where a payment is made by a corporate debtor, not voluntarily, but under threat, or for purposes of avoiding a litigation, or for purposes of getting out of a liquidation proceeding, all of those payments are generally not considered to be preferential payments. Now the problem is that the way the language is currently drafted in the code, it's not completely clear that tomorrow, if the resolution professional was to file an application to the NCLT, whether this payment pursuant to the court order will be considered as preference or not. And there's a very interesting, there's a proviso actually which is there in section 43 of the code, which says that just because a payment has been made pursuant to a court order doesn't mean that it is out of the preferential transaction ambit. So to answer your question, Peswini, I don't know whether this actually will be seen as a preference or not, though I think there is some amount of risk here that Ericsson may be facing, but that's only once the application for insolvency actually gets admitted and if the RP makes an application to the adjudicating authority to set aside this transaction.
Okay, all right. I'm assuming all of this to basically determine whether or not this will eventually be, deemed to be a preferential transaction. So, Sudipta, how are you viewing this? Is it a settlement offer, which is as Pooja spelled out at this stage, but assuming that, we restart or kickstart the IBC proceedings against RComm, can Ericsson be forced to give back this money to the company?
Yeah, and there is a huge risk that that's what's going to actually happen, because not just because of Section 43 alone. The fact of the matter is, if memory serves, Ericsson actually filed an application, pursuant to which the action came about, and that action was to be taken away provided they got paid, and that's the reason why it went to the Supreme Court in the first instance. Now, having served that purpose, it is basically, Ericsson basically used IBC and not in a pejorative manner or anything. They just use the IBC more by way of a debt recovery strategy in this situation. They figured that given the basket of assets in that company and the parlous state of affairs, they would cough up.
Which RComm and the courts agreed to.
Right. So now, if that insolvency proceeding is not withdrawn, then you are bound by the court to follow the waterfall in 53, right? And here is where financial claims will rank highest ahead of operational claims, which are actually in the lowest category in this situation. So you couldn't have done something by way of a contrivance. In this situation, the Supreme Court order also will be looked upon as a contrivance by which you've actually recovered ahead of that waterfall. And in that situation, 43 is, if you compare it with what we have in the UK and what we have in this code, this is a little more well thought out, and it's backed by more jurisprudence. If you start looking at the BLRC reports, you'll notice that they call it a code, firstly, meaning to say it's something different from an act. And if you follow the algorithm here in this code, clearly this will come in as a preferential transaction because it was for the benefit of a creditor, and that creditor claimed far ahead in preference to the waterfall in 53. So on both counts, the fact that they actually used the IBC to get this payment out and then the insolvency action remained where it was will cause this clawback from Ericsson. There's quite a big risk of that happening.
Okay, but that is with the caveat that at one point RComm agreed to it and it has a Supreme Court blessing. But that aside, technically, can Ericsson not argue the debt on the basis of which it had initially filed this insolvency application has now expired, has now been paid? So there is no, action that they would want to pursue against RComm because their debt is paid. So are they not in the right to now argue that let us allow to withdraw this insolvency application?
That's a horse before the cart kind of a thing. Pooja rightly pointed out the look back on this. So any transaction in that 1 year period prior to insolvency commencement date can be called into suspicion, and action can be taken for clawback against a completely closed transaction, if that's what you're getting at. It doesn't matter if the debt was extinguished, and it doesn't matter if in the balance sheet of the company that's actually favorable. All of that just flies out of the window. You will look for whatever assets of the company that has been dissipated in any manner. The philosophy behind this is it's not the company really. Once the company is in insolvency, there is a grave requirement to protect it from certain classes of people, including itself. for the benefit of the other stakeholders. And that's the reason you have these Chapter 3 actions, 43, 44, 47, 50. All of these are designed in that fashion. Yeah, they are not rights in rem. They're not rights in personam. They are rights in rem. It's for all the stakeholders.
In English, it's for it applies against the rest of the world, not one entity.
Thank you very much. Yeah,
okay.
Indeed.
Okay.
So that risk is going to remain open, and if I was with the other financial creditors representing any one of them, I would actually put intense amount of pressure on the resolution professional to actually take cognizance of this. Interestingly, if the resolution professional does not take cognizance of this, you'll notice that only the resolution professional actually has the right to make an application, which is a little bit strange, but then there's a question. Then what do you do in that situation?
Well, because it's assumed that the resolution professional has the best interest of the company at heart.
No, yeah, sure. I mean, that's the basic fundamental sort of presumption here. But if there is indeed one, and the RP has, for whatever reason, not taken cognizance, it does not appear that the code provides anyone else the right to do it. Yeah. But here it's further complicated because the NCLAT has already commented that, listen, we'll take away this application, we will rescind the application provided you reach this settlement agreement. So there's two prongs here. If it was just a single pronged kind of a situation, then the only issue that we could really debate interestedly is what happens if the RP says no.
Okay, so Deepta, I want to take your point on the time period to Pooja. Pooja, when a preferential payment is made to a non-related party, the code says that you can go back 1 year from the day insolvency starts to determine whether the payment was preferential or not. Now, in this case, the admission to NCLT was in May 2018. So what would be the cutoff date to determine, or the look back period to determine whether the payment to Ericsson was in fact preferential or not?
That's a good question, because if the commencement date is May 2018, then actually the payment was made after. Then where is the question of preference? Because the preference look back is seen with reference of insolvency commencement date. But one thing, actually two things which I would just like to say here. According to me, this preference risk is really a risk if the application of RComm or some other creditor really gets accepted and RComm goes into insolvency and the insolvency now starts and we do a look back and say that the Ericsson was paid in priority to other creditors. My sense is that Supreme Court, as far as the withdrawal itself is concerned, that's a completely different issue altogether. Once the payment has been made to the creditor pursuant to a settlement and the creditor wishes to withdraw the application, I don't see any reason why Supreme Court would not allow that withdrawal. If it allows that withdrawal and the company goes into insolvency due to some other reason, let's say Section 10, which has been filed by RComm or by any other creditor, then you have the entire concept of a look back. I'm not sure how preference would be really attracted in case Supreme Court does not allow Ericsson to withdraw. Then it's not really a case of preference, because for preference, you need to count the look back from the start of insolvency commencement date. So again, my sense is that given if Ericsson has already been settled, there is no debt qua Ericsson, in all likelihood, Supreme Court would probably allow the withdrawal, in which case, if tomorrow RComm goes into insolvency, then this preference risk is there. The second issue which I just want to highlight here is, I'm not completely sure what the source of money is for payment to Ericsson. At least what I've been hearing from various newspaper reports is that while part of the money may have come from RComm, part of the money may have actually come from Mr. Anil Ambani's sources or some other sources. So preference really would only get attracted where payments have been made by the corporate debtor. So where payments have actually come from the RComm's kitty, and would not really, according to me, get attracted where payments have been made from some other sources, let's say personally by Mr. Anil Ambani, through any other means. So that's the other distinction. So I'm not here completely clear that when we really talk about the entire monies which have been paid to Ericsson, what part of it will actually get attached to preference transaction and what would not. So I think that's another very relevant fact which the RP will probably need to go into to see what money actually came from the corporate debtor as opposed to any other source.
Okay, so Deepta, so is it in RComm's best interest, if it intends to get that money back from Ericsson, to allow Ericsson's original insolvency application to die, and then some financial creditor initiates insolvency afresh, and then you sort of take care of the technicality on what should be the commencement date for a look-back provision to determine whether this particular payment was preferential or not?
My reading of the code is not complete. I don't remember many things, my dementia maybe. But what has happened is, I think there's a provision now there which says you can't file another application in the period of 1 year. Yeah? I don't remember the section now.
Yeah, that's fine. But essentially it says that once insolvency has been initiated and it has been settled for any reason, you can't initiate insolvency for another year then.
So timing becomes quite crucial when you're playing this game, right? You'll want to maneuver it in a direction where you get that 1 year breathing space if you're Ericsson, and then you're off scot-free. Now, as to whether the transaction is closed, dissipated, debt is gone, I think that is becoming more and more irrelevant in these facts and circumstances. And I'll get back to the second bit, which is also very interesting. I think in these circumstances, even if the application is withdrawn, then a countdown of 1 year commences. In that 1 year, there's grave risk, right? Because
grave risk for RComm, because the payment look-back window will expire for in the context of Ericsson.
See, there is the perception, right? Great risk for RComm. Why? Great risk for Ericsson, maybe.
How so?
Because there's a clawback problem. Because if RComm goes into insolvency, then you can bet that they will definitely make a claim to clawback.
But assume that Ericsson's original insolvency application, on the basis of it, IBC proceedings commence, right? In that case, the question is, what is the cutoff date that you're looking at? Do you look at May 2018 and from then look at preferential transaction in the last 1 year, in which case this payment will not fall under that umbrella?
Yeah, here's insolvency commencement date means the date of admission. So,
which is last year, in 2018, then this transaction is out of that net.
The application not been admitted.
It did. The NCLT admitted, the resolution professional was appointed.
In which situation? That was December 2000.
That was May 2018.
May 2018, right. So from that day, the look back is 1 year.
In which case this transaction falls out of the net.
Yeah, it happens out of the net, but that's a look back. But if you look at preferential transactions, that can also occur during insolvency, during the CIRP.
Okay.
You could have assets being given away or some accounts being operated without the knowledge of the other financial creditors. These things have happened already. Yeah, we've had enough cases out there where during the insolvency itself, funds were taken out or assets were sold. All of that falls within this net. All of that gets clawed back.
Okay, let me take this to Pooja. Pooja, if assuming that our look back period, the payment to Ericsson falls outside of the look back period, what provision in the code then takes care of this payment to ensure that it comes back to the company and then it's allocated based on the waterfall?
Yeah, the provision then you would actually look at is the breach of moratorium, because technically, and that's the tricky part. Anything post insolvency commencement, if any payments have been made for settlement of pre-insolvency commencement date, then that itself is a breach of moratorium provisions, which is section 14. So a lot of cases where payments have been made after the insolvency commencement date, all of that can actually be clawed back under moratorium provisions to say that there was a breach of moratorium provision because the insolvency had started and the payments were made in breach of the moratorium order. But the problem here is that the moratorium order actually got stayed. So where is the question of breach of moratorium provision if it actually got stayed? And that's where it becomes very, very complicated. You don't have a look back if I count insolvency commencement date as May 2018, because the look back has to be counted from insolvency commencement date. I don't get a protection, RComm doesn't get a protection of moratorium provisions because there was no moratorium. The moratorium was under stay at the time when the payment was made. So according to me, if actually if Ericsson's insolvency petition is not withdrawn, or the court says no, you can't withdraw that provision, I'm not sure under which provision you can actually do a clawback if the insolvency commencement date is treated to be May 2018. Now, it's entirely possible that the bench may say, the Supreme Court may say, okay, fine, you're not allowed to withdraw, but we are going to count insolvency commencement date from, a later date, not May 2018. In that case, this could be a preferential transaction. So I think that's where it'll become very interesting. Obviously, if Ericsson's application for withdrawal is accepted and some other application gets admitted, then in that case, you'll have to look back from the time when that petition gets submitted.
But you can't file a fresh insolvency application for another year then?
Well, I wouldn't say that, because your Section 11 is really a case where liquidation order has been passed, or the company has come out of a resolution process, and then for a period of 1 year, the corporate debtor itself is not permitted to do a Section 10 filing. Now, from what I understand here, and I could be wrong, I thought that Reliance had already made a Section 10 filing in the meantime.
Well, they did put out a press release, but they did put out a press release, but I don't think that application got admitted.
It hasn't been admitted. It hasn't been admitted. So that application is still pending, though. So if Ericsson's application for withdrawal is accepted, then it will be deemed that there was no insolvency process to begin with. So the entire proceedings would actually be not considered as an insolvency resolution proceeding. So in that case, the Section 10 petition of Reliance can actually get admitted. And then the look back period will be from the date when it gets admitted.
Okay, all right. So, Deepta, the possibility of Ericsson to return this money stemmed from, or rather was recorded in the NCLAT order. The Supreme Court didn't expressly state anything to that effect. So, can I not argue then that this payment to Ericsson didn't come with this baggage of, oh, you might have to return this money?
No, it didn't, but it came with the condition that they'll withdraw the insolvency application, right? That's when the settlement agreement came into being.
Right,
now,
which they are doing, which Ericsson is saying that allow us to withdraw.
But the substratum, it was predicated on removing the proceedings altogether, wasn't it?
Right, which Ericsson can withdraw, and this particular proceeding can come to an end then.
Yes, but that doesn't stop someone from filing another insolvency petition immediately after that, because Pooja has rightly pointed out to 11B. It means having completed corporate insolvency resolution, and here there is no such thing happening. There is no insolvency admittance. Firstly, we are not sure what is happening with that, and there is no insolvency resolution process which is started. So tomorrow, if I was one of the financial creditors, I'd go ahead and file this resolution, this application, and start insolvency proceedings all over again. And the risk doesn't really go away. Okay,
if you were advising Ericsson today, what would be your argument against repaying this money back?
If I was advising Ericsson, the first thing is get the insolvency application vacated quickly enough and hold your breath.
Okay. On that note, Sudipta, Pooja, thank you for giving us the perspective with the limited information that we have. And it's very difficult to then crystal gaze into how the arguments are likely to pan out in the Supreme Court. But thank you for doing your best, and thank you so much for watching.